turn the sound on.
Hey everybody, how are you doing? Welcome back for another Boozy's Legal Funhouse. I've got a few people joining me tonight, but before I do that, as with every stream, I have to read off the names of the Patreon supporters from lawyersandliquor.com who support us at the $5 level and above. So, special thanks to Jeremy the Head Fox and Dragor, Jack of all Corgs, Nikolai, Tezcat Magic Jack, Wayland DeRoche, Beat and Dose of the Trash Panda, A the Weather Fox, Mark Beckwar, Mama T, Uncle Kage, Lisa Lupe, Mark Phaedrus, Netherlinks, Petrov Neutrino, Scott Skunk, Terrence, Buddy Goodboy Esquire. CC Otter, David Hunter, Ed B. Cali, Feck, Ghost Goat, Grace Jane Gallinger, Ian Delahorn, Jason Knight, Coma Bloodpaw, Maelstrom, Mark Whipple, Matt Allaire, Michael Blocker, Pandemonium Hawk, Sean Rabbit, The Dragon Show, Wheelie, and Zeros Lion. So thanks to all of you. Now, as you know, I am the Boozy Badger / Boozy Barrister. I figured if I read off the name of so many animals, I should probably go with the Badger tonight. And this is Boozy's Legal Funhouse, a 1 hour and change talk where we discuss current legal matters, issues, cases, and general law. I've got a couple guests with me tonight. Would you all like to introduce yourselves?
Hi, I'm Boozy Badger.
Okay, fuck you. That's my shtick.
I am Buddy Goodboy. I'm an in-house attorney, and that is going to be how, that's going to be my angle for things tonight. So I think we're talking about professional ethics.
Yes.
Let's all say it together. You're lawyers. You don't have ethics.
Yeah, as a matter of fact, I named the stream Legal Ethics and Other Fictions. So.
That's pretty good. I like that.
Yeah.
That's all I got. I'm done. Sorry.
I am Scuffles, Scuffles the Rat. I am a prosecutor and have been for the last 9 years and change, and I will be discussing prosecutorial ethics.
And I'm Boozy Badger, your host. I'm an attorney in Pennsylvania who practices a little bit of everything, from people walking in the door on $200 tickets all the way up to multi-million-dollar multi-state fraud cases. And I'll be talking about legal ethics in a general sense. So, for tonight's stream, we obviously have, as always, the questions of our Patreon supporters. If you do like the stream, you want to support us, you can always do that by subscribing to the Twitch channel, by tossing your bits all up in our faces. I'll even make Buddy lick them, unless Scuff wants to lick your bits. Scuff, do you want to lick their bits?
I'd have to take them out on a date first.
You'd have to take them out there, buy them a nice steak or something, get a wine and dine them.
A nice cheese platter. Yeah. Look.
Or you can go to boozybadger.com or streamlabs.com/boozybadger. Peruse our merchandise or slide a tip into the bank account. Just the tip, though. I don't want to get pregnant. All that said and done, tonight's topic, as we discussed earlier, is legal ethics. The ethics that control the legal profession. And in that vein, we have 3 stories tonight of news. We always start with a legal news update taken from the ABA Journal that are directly on point, with the exception of the very first one. Now, let me ask, I sent you all a number of articles and legal opinions today. Did you motherfuckers do the reading?
Yeah, sure.
I've read most of it.
You've read most of it? I did some of it, Boozy.
Look, this is very much like college classes for me. I'm reading some of it as we're going along,
like you're getting cold.
This is my law school experience too. Like, just hoping that I get the reading done right before you call on me.
Like, look, going to outlines.com and looking at the case brief like 3 seconds before you're expected to give the answer.
Oh yeah, exactly.
It's worked for me before.
That's how I got through property.
That's how all of us got through fucking property. You're not unique in that situation, motherfucker. I hate to tell you. Let's go to our first story tonight from the ABA Journal. It's a real shocker. I'm certain we're all going to be amazed. Thank you, Dr. Quaxum, for subscribing. And we're all going to be amazed to hear this. But after cutting lawyers in a pace reminiscent of 2009, law firms see net income rise nearly 10%. Now, I know you out there are saying, what the fuck does that mean in a pace reminiscent of 2009? Anybody want to describe the legal employment atmosphere in 2009 for our viewers?
Oh my God, that's the year I graduated law school, Boozy.
Yeah, is that why you're a prosecutor now?
That might be. That might contribute to it. So To understand what happened in 2009, you have to understand how big law works. So law is divided into different areas, but at the time, when I graduated law school, they had a statistic that everyone who graduated from my law school, 90% of all people who graduated would end up in of two camps. They would end up working for a law firm of more than 100 attorneys, or they would end up working for the government. 90% of the lawyers who would get jobs would work for the one of those two. By the end of the year I graduated, that number was down to about 40%. So big law collapsed in 2009 because of the collapse of finance. Because a lot of these big law firms basically exist on accounts receivable. That is, they bill out to these big companies with the promise that they'll get paid in later. And they get paid in over time. They're essentially financed by these account receivables that are earning interest, and they pay out their bills. Well, in 2009, a lot of this money started disappearing, but law firms have fixed costs. They have employees, they have rent, they have to pay out. And all of a sudden, this financial squeeze happened, and they didn't have cash to pay out all the money to, for instance, all their associates who are guaranteed salaried income, all of their secretaries who are guaranteed salaried income. And so they just started two things: laying off anyone they could, but also they just didn't hire anyone. So it was a bloodbath. It sucked.
Yeah, and never really quite recovered to the level that it was before that either. I mean, staffing levels are the same, just absolute cut to the bone level that they were in 2009.
No.
Yeah,
You mean law partners like to keep the money they're making?
Well, and
yeah, I know
now
it's an odd thing, but we're living in the system called capitalism, where them with the gold makes the rules.
Well,
Well,
and now you have what's going on in Arizona and Utah, where they're trying to older attorneys as they get to the end of their career. It used to be the case that you could not sell a law firm to a non-lawyer. So
mhm.
what you had to do if you were a partner is you had to cash out your ownership of. So a partner is literally a partner in the law firm. They own a portion of the law firm. When an attorney went to retire, you had a negotiated settlement where they would sell their partnership interest back to the firm, which meant that the firm then had more interest to pass around and then potentially raise other people up to partner. Right now in Arizona and Utah, they're working on systems to sell to non lawyers because the assets that big law firms hold, not just their account receivables, but the buildings, the real estate that they own, all of that's worth money, and it's probably worth a lot more money if you have to compete to buy back their interest with private equity firms who really just want the holding, they don't want the law firm. So it's going to get worse before it gets better, because now we're going to start seeing a situation in which these equity situations don't go back to the firm, they go out to outsiders who have no interest in making new partners because that's less money for them.
Well, and before we move on to the next news article, you brought up something nice there, which dovetails perfectly in to our topic for tonight, legal ethics. The reason that non lawyers cannot generally own law firms. Now, you have to understand that in the legal profession, there is no one overriding rules of professional conduct book. It's jurisdiction by jurisdiction. But generally, most jurisdictions base their rules of professional conduct off of something called the Model Rules of Professional Conduct, which is something put out by the American Bar Association. It's kind of like a lobbying group for attorneys that writes these things. And by and large, that is the set of rules that the legal profession works by. So, I have to do my disclaimer very quickly. All right. I am a lawyer. I am not your lawyer. Okay? Nothing that you are going to hear tonight should be considered legal advice. This stream is for educational, informational, and entertainment purposes only. The only way that I become your attorney is if you come to my physical office location. If you pay me a fee that I set, if I agree to represent you, and you sign an engagement letter retaining me for your legal purpose. I am not your lawyer, and there is no legal advice from this stream. Anything you hear tonight that may apply to you or a case in your mind, please run by a licensed attorney in your jurisdiction. For the love of God, do not say a fat man on the internet who pretends to be a badger told me this. That said, and we have to cover that every stream. I assume it applies to you all, except with a rat and a dog instead of a badger.
I don't take private clients, so I'm definitely not
Yeah,
yours.
You're definitely
Likewise.
well, no, I mean, like, you're everybody's lawyer if they're in the state of Kansas.
Yes. No, actually, I am literally the state of Kansas's attorney.
Well,
I am not yours.
The state derives its power from the people. Scuff.
Who gave you that silly idea?
The Constitution, asshole. Regair Fox, thank you for subscribing, and welcome to your very first Legal Funhouse. But as we were saying, that is not just like some weird attorney thing that only lawyers can own law firms. That is actually, and I'm transferring over to it right now, ABA Model Rule of Professional Conduct 5.4. 5.4a states a lawyer or law firm shall not share legal fees with a non-lawyer, except to some very, very small exceptions. That we cannot form a partnership with a non-lawyer if the partnership consists of the practice of law, and shall not allow a person who recommends, employs, or pays the lawyer to render legal services for another to direct or regulate our professional judgment. We cannot practice in the form of professional corporation or association, authorized to practice law, if a non-lawyer owns any interest therein, is a corporate director, or has the right to direct or control the professional judgment of the attorney. Now, reason that is very simple. As attorneys, we are not just business people. We are professionals who undertake, as part of our job, the zealous advocacy of our clients. And while we do expect to make a living doing this, we do not believe that non-attorneys, people who are not beholden to our ethical rules or constructs, should be able to direct our decision-making in cases, the practice of law, or the representation of our clients. And when you get into the reality of it, buddy, what system do we live in again?
Capitalism.
When you get into the realities of the system that we live in, the fact is if somebody has an investment in a law firm, they expect the law firm to post a return. And as we'll see in at least one of our example cases tonight, you sometimes can't make decisions financially in the practice of law. As I've told clients before, once I'm in a case, I'm in the fucking case unless the court lets me out. I don't get to just say, I'm not being paid, so go fuck yourself. And I have to ask permission to leave the case. Unlike you two assholes, because one of you isn't in cases, and the other one doesn't work privately. So, fuck both of you.
Yes, I do all my work in public. Rip.
Let's go over to our second news article for the night. This is regarding a district attorney. Scuff? A district attorney. They are bastions of the criminal justice system who never do anything wrong, except for the one in Pennsylvania who's been charged with sexually assaulting his clients. A Pennsylvania district attorney has been charged with sexual assault and indecent assault in connection with the alleged coerced sex acts with 5 women who were clients when he was in private practice. Bradford.
I got you there.
Yeah.
He wasn't a DA when he represented them.
No, he wasn't. And
there you go.
I'm just got to tell you, it's not like that's a good thing. But his Bradford County District Attorney Chad Salzman was charged by a state investigation grand jury and Pennsylvania Attorney General Josh Shapiro. They stated he would regularly use his position and power as an attorney to coerce his victims into performing sexual acts on them. He would bring them into his private office under the guise of discussing their case and used his knowledge of his clients' vulnerabilities to negate their consent and sexually assault them. It would seem like there may be a model rule about this.
Yes, it certainly would.
Yes, scuff.
Scuffs.
I cannot cite the model rules off the top of my head.
You can't.
No.
You like you can't sit there and say that you can't cite them
I can
off the
definitely
top of
say I
your
can't
head.
cite them off the top of my head. I know the relevant rules to me. Also, those are model rules. Those aren't my state rules.
This is actually a pretty
Yeah,
common rule. I mean, like you're like, oh well, that those are the
I am
model
sure.
rules.
Yes, I am sure
They're
it's a
not
rule.
they're
in my
not the
state.
state rules. I mean, Jesus Christ, buddy. And that's like, hold on, let me. I actually can't say it off the top of my head, anyways. But let's take a look on that. I actually have to Google it. Like I know it's bad, but I have to Google it. Professional rule sex with clients. I can't believe I have to Google this one.
I mean, there's the catch-all. There's the
Well, you know the general rule,
conduct
and that's
unfitting for
don't.
our profession.
Yeah. Don't do it. It's 1.8 specific rules, and I'll go ahead and bring that up if I haven't already by accident. But yes, it is model rule 1.8. Current clients specific rules, and it is where is it 1.8 compensation represents two or more clients.
Oh, J.
Oh yeah,
1.8 J.
1.8 J. A lawyer shall not have sexual relations with a client unless a consensual sexual relationship existed between them when the client-lawyer relationship commenced. Now,
So you got a clear loophole right there.
yeah,
Have
yeah.
sex with everybody.
Well, it's so you can represent your wife, or your husband, or
is
your
that
girlfriend, or your boyfriend, or something like that if you want to. But why? And I would like to ask, keeping in mind this news article, why would that rule be in existence for an attorney?
There's conflict of interest rules.
But
Well,
why is it a conflict of interest? Why can't I just fuck my clients? Is it because you don't want them to pay twice for the same service?
you've got
You can either
specific.
fuck them metaphorically or literally. You can't
Yeah,
do both.
you've got specific rules and duties to your clients, and you don't want your sexual relationship to interfere with your responsibilities to them.
Well, that's one, but we just heard from Mr. Salzman here. And taking a look, and I'm not going to put this up on the screen. I will just say it's an 18-page grand jury indictment and criminal complaint with 5 specific clients. And in each situation, there's one thing that is in common. Mr. Salzman was being retained for representation, and Mr. Salzman, as part of the representation, allegedly forced clients to send videos or nude pictures or engage in sex with him in his office while he played loud music so his staff wouldn't know what was going on, or things such as that. And wouldn't you say that creates a bit of a power disparity?
It definitely does.
There we go. And that's the big part. It's why we have so many model rules that are intended not to protect the attorney and not necessarily to protect a specific client, but to protect society in general from lawyers.
I think that's a good thing.
Yeah.
Yeah, that's a good cause.
I mean, everybody needs to be protected from lawyers. I myself am an asshole.
Yeah. I need protection from lawyers all the time.
And you have to understand, because some of these rules, when you cover them, especially in law school, you're like, well, who the fuck would ever do that? Who would ever do this?
I worked with an attorney who was an elected county attorney, and he was indicted by the feds for stealing like $75,000 worth of county supplies when he was the DA.
Right. It happens all the time.
It happens.
There was a guy in my town who won $1 million personal injury suit, ran off with the money. Like, they still haven't found him.
Right. These are actual things. This is why we have these rules, and we write them for every contingency. I mean, there's a lot of things out there that you wouldn't think a lawyer would do, because we are educated and we are bastions of legal service, and we have to have a model rule telling us specifically that we can't use our superior position over you to coerce you into sex, because it definitely fucking happens.
Right. If there's a rule for it, that's because it happened.
Well, and sometimes,
and does happen.
yeah. Like, let me ask. I know that you all are not in private practice, but if I find out Bob has a car accident, can I go down to Bob's house, knock on his door, and say, "Hey, Bob, I heard you were in a car accident. You want to hire me?"
Heck no.
Why not?
No, there's specific rules on solicitation of clients.
That's right.
Again, that's a case of you using your superior knowledge of the law and in people in vulnerable positions to coerce them into accepting your services, whether they really want them or not.
Right. Now, let me ask, has anybody here been in a car accident, something like that, gotten a letter from a lawyer?
Oh yeah.
How's that not solicitation?
Well, I mean, it makes a difference how they get in touch with you. I mean, obviously, you don't want to have an attorney standing over somebody's hospital bed pressing a pen into somebody's hand for a letter of engagement. That's obviously an abuse of power.
Right.
But I mean, if somebody's been in a car accident and somebody buys a list off an insurance company of payouts that they've made, these kind of things do happen. That's actually gives them the choice to come to you or not. They can just ignore that.
Right. The specific rule we're talking about is Model Rule 7.3, solicitation of clients. And generally, it only applies to in-person communications. There are exceptions to the model rule. We can have such a contact. Like, I can go to Bob's house and do that if Bob's a lawyer. I can go to Bob's house and I can do that if he's a close personal friend. I can go to Bob's house and I can do that if Bob has used my services in the past and is a regular client of mine. Why? Because in those situations, they're not so worried about the lawyer convincing you to do something you wouldn't do otherwise. The reasoning that I got in law school for this, and is held true, is we are literally people who are paid to convince you of something. That's our job. That's like 90% of being a lawyer if you're in any type of litigation or negotiation or trial work, is we are paid and trained to convince people of things. And they view it as unfair for you, little Larry Layman, to get in a fender bender and all of a sudden have a lawyer sitting in your living room convincing you that they are the best person to take the case when you haven't reached out first to them. Letters, however, don't have that issue. I send you a letter, you can ignore the letter. I'm not sitting there pressuring you to do anything. Yeah, what is an interesting area? How many people send fucking letters anymore?
Well, you would think that not a lot of people do, but the bankruptcy mill that I used to work for, they would buy lists of people who had, who had had their cars repossessed, who had bad credit, foreclosures, that sort of thing, and just mass mail every week, basically copies of our, I'm blanking on the word, like a pamphlets and advertisements saying what our services were.
Well, right, the letters are fine, but right. Outside of lawyers and junk mail and debt collectors, how many people actually send out a letter when they want to talk to you anymore?
I mean, I have sent my fursuit pins in letter form, but that's about it.
I've fuck, do I have to be as a form of novelty, but nobody.
Yeah, like I think I'm being pretty fucking clear what I'm getting at here.
Yeah, I get what you.
Don't ask rhetorical questions, otherwise we're going to try and frustrate you.
Yeah, exactly. Well, I've noticed you.
That's part of our
fucking
job.
Pricks. Emails. How many of you have ever gotten an email from a lawyer saying, "Hey, you got a speeding ticket? You want to hire me?"
Never.
They take down your phone. No. They take down your phone numbers. Have you ever gotten a voicemail, a robocall? Hey, review of records has shown a foreclosure has been filed against you.
No.
You know why? It's the instantaneousness of the communication. The fact that there is no downtime. If you enter a chat with an attorney, the attorney is in that. While you can disconnect, you're much less likely to. So it's kind of a gray area, and they've kind of said any form of instantaneous communication we're going to treat as solicitation. Now, fun fact, could lawyers always advertise?
No, that's new.
That is
It used
relatively
to be
new.
word of mouth only.
Yep, that is relatively new for the practice of law. It was seen as uncouth and unethical to advertise your services as a private attorney out there simply because of that.
And frankly, I kind of agree with that as far as it being uncouth. I saw one on TV the other day for, and it was the most insulted I've ever been by an ad. But a local attorney put out an advertisement on TV specifically targeting people who'd been um, victims of a liquid nitrogen accident in a factory nearby. And this happened last week. Like, he spent no time at all getting his ad ready for this thing. And it just seemed like it's such bad taste to try and get money off of these folks who are still in mourning.
Oh,
Well,
yeah.
and also you never. So around my town, there's an advertisement series for jungle law, and it's this dude who looks like Tarzan. So he is. There are these big cheesy posters that's like he's riding a wasp, and it's like stung by a DUI, jungle law. But what a lot of people don't know is that this guy doesn't actually take many cases. It's a referral mill. So for those of you,
Hi!
Hi. Yeah.
give me a second. We just got back on. I lost everyone. I lost everything. Like in the middle of this, my internet just went. Well, you know what? Fuck you in particular. But I got back on quicker than normal when that happens.
All right.
well,
So not the coyote child running away with the router.
No, not this time. Thank God. Thank God.
oh man, it's a
He's
shame
a
that that would
smart
cut out.
kid.
It's a shame that that would cut out your stream because that would be a thing to see. But
Yeah.
yeah, like a lot of the advertisements anymore are for referral firms. So it's a bigger scam. They're not even advertising legal services. They're advertising to send you to somebody else so they can collect a fee, which
Yep.
is ridiculous that that's allowed.
Yeah, it's horrible. Let's go to our last article on the new news for the evening. You know, just in case you thought attorneys fucking their clients, literally as well as metaphorically, was an isolated incident. No, it happens a lot, except this time it wasn't a client, it was a high schooler. The acting Alaska Attorney General has resigned amid allegations he had a sexual relationship with a high schooler in 1991. Acting Alaska Attorney General Ed Sniffen, very unfortunate name for that gentleman, Ed Sniffen. Can you just imagine? Like, that just sounds like a predator's name, doesn't it? Like,
Yeah.
like
That's unfortunate.
that just, like, what's your Attorney Sniffen? Why aren't you the acting AG anymore?
Sniffing.
Yeah, Sniffen. But acting Attorney General Ed Sniffen, it was reported, in the 1991, was coaching a moot court team when he began a relationship with a now 47-year-old member of that team. At the time, that member was 16 years old. The age of consent at the time was 16. Counsel or coach teens who were 16 and 17 were barred from having any contact, though, with them in a sexual manner. Now, it actually states that for about 2 years after the relationship began, they lived together in Anchorage. They eventually married other people. Mr. Sniffen was 27 years old at the time. He has resigned, and just to show the quality of the Alaska Attorney General's office, he was the acting Attorney General appointed after Kevin Clarkson, who had acknowledged he created an uncomfortable workplace environment by sending more than 550 text messages to the cell phone of a junior employee telling her she was beautiful and including dozens of kissy face emojis.
Well, at least I've never done that.
I mean, like, are you sure, buddy? Have you ever sent 550 text messages of nothing but kissy face emojis?
Not to anyone but you.
Buddy, I thought we weren't going to talk about that.
We got to talk about it sometime.
Like before the stream, by the way, we were sitting here and we're like, we're all being really comfortable with each other. And Scuff, what did you say?
I mean, we've all seen each other's butts.
We have all seen each other's butts. This isn't a sex thing. It's a rite of initiation into the bar. We all get alone in a room, drop trowel, and criticize each other's asses. We are the anal attorneys.
Wait, you criticize. I only compliment.
Well, yeah, constructive criticism is good.
I like all butts.
You have the butt of a litigator.
Oh god, the sorting pants.
Tight enough to make diamonds.
Now that said, as with the topic,
That's how we all get our specialties. You put on the sorting pants. Litigator.
the topic tonight obviously is legal ethics. We have been discussing it on and off, and these cases were not chosen randomly. The news articles, I actually went out there and looked for ones that specifically matched in with the questions of legal ethics. But I find it's always really good to kick off the last half hour of this, the 30 minutes we talk about. Like one night I'm going to say like we're going to go an hour and a half, but tonight's not going to be that night. By the way, Silver Gatomon, thank you for your 35th month of subscribing. You are 1 month away from 3 years of this shit. Let's see. The first question is from somebody who I've never heard of before, a Boudet Gooboy.
This was before you asked me to be on it.
who asks, what are some of the resources available to a lawyer with an ethical dilemma, and have you ever had to use one? I'll start off. The most common resource that you have in the practice of law, especially in firms, for any ethical dilemmas that you may have, is going to be a mentor. It's going to be an older attorney who has been there that you can run things by. A lot of large firms will actually have a designated ethics counsel who you are supposed to go to with any ethical questions. For small firms or mid-sized firms or solo practitioners, most state bars actually run anonymous ethics hotlines that you can contact and ask ethics questions. And you can always ask your ethics board. Most ethics boards have a way for you to submit a question to them for them to consider and give you a written ethics opinion back on before you do something on that. It takes longer than the ethics line in many cases. Have I had to use them? Yes, I've called the ethics line before. I've had situations arise and going through things. I'll see, it's not like any of these other situations. So I've put in the call to the ethics line to say, hey, I've got a question. Is this ethical? Can I do this? Or where I think I've had a close case, a conflict. Maybe I represented somebody or I consulted with somebody in the past, but I didn't represent them about something that's close to, but not the same thing as, like a financial issue. And then 3 years later, I've had somebody come in and they want to hire me to sue that person. And I'll call the ethics line and say, yeah, this is the information I got from them 3 years ago. It's probably out of date. This is what this new thing concerns. Do I need to get a waiver or something along those lines? Now, when I say waiver, what are the two types of conflicts an attorney can have?
Waivable and non-waivable.
What is a waivable conflict?
Anything where if you have disclosed what your conflict is to the client, they can then say, I understand you have this conflict, but I still want you to represent me.
What is an unwaivable conflict?
The conflict is so severe that even if your client knows about the conflict, you are not allowed to represent them.
Here's a classic example. Tim and Darla come in to me for wills. They're married. Okay. I represent them in the will case. Okay. And in that, I get a full view of all of their assets, individual and marital. 2 years later, they're getting divorced. Tim comes to me and wants me to represent him, but now Tim is telling me that he has undisclosed assets that he wants me to hide from Darla. I cannot represent Tim for I have represented Darla in the past, and I have gained information about her assets and his assets that would hurt them. It is a directly adverse party. What about former clients?
You still have ongoing obligations to your former clients. So
Even after you're a client, if somebody comes into me and they would be directly adverse, especially if I have received information in the course of my representation of you that would harm your case, I can't represent them. In some situations, I can, as Scuff said, get a waiver. Now, Scuff, I gotta ask, because I can speak from the private attorney standpoint. What ethics guidelines do you all have there in the DA's office?
just with regards to conflicts, or
No, in
with
general, just in general.
Oh, okay. So, in general, there are three main ethical considerations that every prosecutor gets drilled into their head. The first is what we call Brady, but it basically means that if I have potentially exculpatory information in a case, I must disclose it to the defense attorney. So, if I'm in my office one day and a victim calls and says, "Hey, everything I said, I just made up," I can't call that witness in and try to convince them not to tell the defense attorney about it. I've got to disclose to the defense attorney um, that there is potentially exculpatory information out there that they could use. And I was actually telling Boozy that I had a story where I found this information once and just
Uh,
randomly and almost
I
proceeded
feel
with.
I feel I have to interrupt you. We keep using the word exculpatory, and you're gonna need to break it down
Oh,
for
sorry.
non-lawyers.
I am so
Like
sorry.
otherwise, we're just
This word
like
is so drilled into my
we
head
can
that
we can all sit here and just
yeah,
start speaking Latin, but I feel
in
that it would be better to tell
exculpatory
people.
evidence is any evidence tending to show that the person is innocent or that would help a defense. So exculpatory is evidence that is good for the defense. Um, so this is drilled into our head for a long time. And by the way, any information at the hands of the state, even if the prosecutor prosecuting it doesn't have the information, is Brady material. So and this comes up in our practice all the time on domestic violence victims. Sometimes when they go in, they make their report, they say my partner beat me up. A week later, they won't want to prosecute and they go back into the police station and say, "Hey, everything I told you a week ago was a lie." Every once in a while, the person sitting at the police desk will write them a ticket for making a false police report. This ticket does not come to the district attorney's office. It's a municipal ticket. It's handled entirely on the municipal side. The fact that they wrote that ticket is exculpatory, but the district attorney's office may never know about it. Our failure to disclose that ticket to the defense, even though we didn't know about it, is a Brady violation and can result in the reversal of a case. Now,
You
usually
keep
won't result in any disciplinary action because it wasn't intentional,
you, you
but
you keep
they do.
saying Brady violation, and I feel it's important to explain what Brady is so people understand some of the prosecutorial ethics that you operate under.
Sure. I don't. I only know the legal conclusion of or of the Brady case. So if you know the actual facts,
No,
you
fuck no.
can. Okay. The Brady case is just a case that says if the prosecutor has information at their hands that could aid the defense in presenting a defense, and we don't turn it over, the defendant is likely going to receive a new trial. And if the state does it intentionally, there's a good chance that the prosecutor might lose their license. So yeah, that's why what we call Brady material is any material where the information could be beneficial to the defense. The second big thing we get drilled on anymore, and this is newer, is pretrial publicity. And thankfully, I'm out of the realm of legal terms. Pretrial publicity is exactly what it sounds like. Prosecutors are in most states now barred from making public comment about cases that could materially prejudice the community against the defense to the extent that they could not present a fair defense. This has not always been the case, and it's getting bigger, but it's drilled into our head right now. You have to be real careful about what you say about the defendant. It can come back to bite you in the ass if you're going on Facebook, and social media is a big one. You know, prosecutors are human, and a lot of them like to run their mouths, and some of them like to run their mouths on social media, and it can come back to bite you in the ass because it's bad pre-trial. Like there are rules about pretrial publicity, and then the third thing is conflicts of interest. Um, you can't prosecute a case where you have a personal investment, and this actually becomes a big deal in small towns where there have been cases where prosecutors have been disbarred because the neighbor and them get into a land dispute, and they're like, well, if you don't give me what I want, I will prosecute you for theft. And then they have been disbarred for, among other things, blackmail and also, conflict of interest. So in both counties where I've worked right now, my boss, the elected district attorney, has been the victim of a crime. When that happens, our office does not prosecute those cases. We send them to the attorney general to then assign out to a special prosecutor, and they either hire a private attorney like Boozy, or they send it to a different county to prosecute. But our office doesn't touch a case that my boss is personally involved in.
Now, and I should mention, I'm going to flip over real quick. There is actually, because Scuff is talking criminally, and it is taken much more seriously in criminal matters. But the rule that Scuff is talking about, trial publicity, is actually Model Rule 3.6, and it governs both criminal and civil matters that are triable by a jury. Specifically, a lawyer is participating in or has participated in the investigation or litigation of a matter shall not make an extrajudicial statement that the lawyer knows or reasonably should know will be disseminated by means of public communication and will have a substantial likelihood of materially prejudicing adjudicative proceeding in the matter, a court hearing, a trial. The idea being that we don't want to taint the jury pool. That we should not be allowed as attorneys to go out there and make statements that will taint the jury pool. Does that mean that you can never make a public statement, though, Scuff? Does that mean as a lawyer you can't give a news interview about your case?
No, you can give statements. You can give statements about factual information, particularly if that factual information is public. You can give basically a recitation of facts that are likely to come out, but you can't then say, this defendant is an animal who preyed on the weak like a cheetah running after a gazelle. I don't know why you would say that.
Now,
because you know your audience on this stream.
Yeah, and I will say that unfortunately, for a long time, pretrial publicity was not really well enforced, and people got into some habits of saying some things. And the old guard still, it took them a long time to figure out that you couldn't do that anymore.
Moving on, because I want to get all the questions in from our Patreon supporters and our Twitch subscribers. Speaking of which, if you do become a Patreon supporter or a Twitch subscriber, as long as your Discord is integrated with Twitch and Patreon, you'll automatically be added to the Discord. And every week I'll tell you what the topic is. You can post questions into the Legal Funhouse chat for us to ask on stream. Head Foxen had asked, is there a national standard set of ethics rules or does it vary from state to state? We did answer that earlier. It varies from state to state, although by and large they're mainly based off of the model rules of professional conduct from the American Bar Association, which is what we are reviewing. Tezcat the Magic Jaguar, which in any other professional podcast would sound like a weird name to be reading off, has asked, are there any states that do not require professional ethics for CLE guidelines?
Do any states not require the NPRE?
No. Just CLE ethics hours.
Oh, Maryland?
So
Isn't it
continuing
Maryland?
legal education for the
Oh,
audience?
Isn't the answer Maryland?
The answer is every state that does not have a CLE requirement does not require professional ethics rules. I looked at this earlier. There's actually more than just Maryland. There's a couple of them out there, yeah.
Who are the assholes, and how can we shun them?
Yeah. However, every state that requires lawyers to take annual continuing legal education courses requires some form of an ethics or professional responsibility course, or social media, or civility, which really are all just ethics hours. Like everything I just mentioned falls under attorney ethics. Uh, Next question that we have here. With recent events showcasing alleged issues of police actions, where does jury nullification stand to combat this issue?
I mean, jury nullification is, if you read the case law, they'll say this: jury nullification is not a legal standard. It's a phenomenon where a jury can make a decision to find someone not guilty for any reason they want, and juries cannot be questioned on their reasons for finding someone not guilty, so they can nullify a verdict. Um, Defense attorneys are not technically supposed to, in most states that I'm aware, argue for nullification in like a closing argument. Um, we try to screen part of a prosecutor's job, not related to ethics, but just being a good prosecutor, is in voir dire, or in jury selection. When we're picking a jury, we try to ask questions to weed out people who are there to nullify verdicts. It doesn't always work, but that's where jury nullification falls. It's a phenomenon. It's not a legal standard, and theoretically, defense attorneys are not supposed to argue for nullification.
What Scuffs is actually getting at, and I actually had to look at this one today as well, because I know what you just said, which is attorneys aren't technically supposed to be arguing it. However, there's a number of Supreme Court hearings or opinions that say jury, as Scuff had just said, we don't get to question the jury. We don't get to say, no, I was held on an improper standard. However, what I had found was most jurisdictions that have argued that arguing for jury nullification is unethical have done so under 3.1 meritorious claims and contentions of the model rules, which requires an attorney, when defending a proceeding, to assert or controvert the issues on the basis of law and fact that is not frivolous and includes a good faith argument for extension, modification, or reversal of existing law. And what a lot of jurisdictions have done have said, an attorney can't argue for jury nullification, or you have to bring a motion and ask it, and the motion's always denied, and then you've got an issue with not obeying a court order that makes it an ethical issue. The way around that is to not argue for jury nullification while arguing for jury nullification. I mean, yeah, well, you don't say you as the jury are not bound to find this way, because technically they are. They're kind of bound to consider the evidence and make a ruling based on it. But you imply very heavily that the situation is such where they shouldn't return a guilty verdict, even if your person did everything they were accused of doing.
Yeah, which is, you can do that. In fact, I have lost cases because of that.
Now, it is threading a needle, because there are rules out there that say what we can and cannot do in the courtroom ethically, and we have to argue things on the basis of the law or the evidence. A lot of times, we can't just make flat out, bold, blatant appeals to emotion constantly. But
sorry, I'm thinking of some 60 odd cases that have been filed recently frivolously with no factual basis, appealing to emotions.
Oh,
but as you were.
Yeah, no, but the people who are following them are coming under scrutiny at this point in time.
Yeah, I read about that earlier today. Lynn Wood, I guess.
Yeah, we talked about that last week as well.
I'm so slow. It took me a good 15 seconds to figure out what you were talking about.
Yeah, that's that just means that you haven't been thinking about it constantly for the last year, so that's a good thing.
My work does not let me think about anything constantly that isn't my work.
Now, we have one more question from the Patreon chat, which is with regard to the discarding of evidence after it is no longer required by law, would it be considered an ethics violation if said discarding is done improperly?
Yeah.
From the from the private side, I can tell you what that is. From the private side, what you're talking about is the retention rule. It requires attorneys to hold on to the case file for a period of time after the closing of the case. On the private side here in Pennsylvania, it is, depending on the type of case, between 2 to 6 years. After which time, because believe it or not, your case file, the documentation in your case file, is your property, with some exceptions. Like my thoughts and impressions, my memorandums, my notes, that's not yours. Fuck you. But pleadings, things that I receive in the course of your case, that's your property. I'm just holding it for you. So it falls actually under the attorney's safekeeping of property. That would be Rule 1.15 under the model rules. And I have to hold on to it. And then before I dispose of it, I tell you in my engagement letter, I'm going to hold on to it for this many years. And at the end of that time period, I'm going to send you a letter. And I'll offer to have it made available for you. And then I'm going to destroy it. So I can destroy it however the fuck I want after that time period ends. There's nothing for me as a private attorney that requires me to hold it in a certain manner. Now, Scuff, what about you with the state?
I was just going to say, do you prefer fire or do you prefer explosives?
Fire. I use fire.
There are specific rules, and unfortunately, because anytime you're in a bigger organization, it becomes people's specialties. It's just not something I've ever had to deal with. I've never been on the admin side where they go into it. We typically try to hold evidence to the way you try to do it is you make administrative rules. So basically, we will hold evidence until a certain time period has elapsed. We usually hold evidence to the end of when a case can be appealed, and then plus X number of years, and then it can be destroyed. And there's got to be an administrative process in place for like when you're destroying it and everything. So it only becomes an issue if down the line a case is reversed for some reason, and it goes. The big misconception about when cases are reversed on appeal is people think that when a case is reversed on appeal, a person is basically found innocent by a judge. Typically what happens is that the conviction is reversed and then the state is given an option to re-prosecute. Now, the issue becomes if you destroyed all the evidence, there's nothing to re-prosecute. So that's where it usually comes in.
Now, and we may go a little past 8 tonight because, buddy, I want to get onto you about in-house counsel and your special ethical obligations as in-house counsel as well. But somebody in the chat just mentioned Brett Kavanaugh in his hearing and his emotional appeals and all of that. And it made me think for a moment, when you are not acting as an attorney, are you still bound by the rules of professional conduct?
Oh, yeah.
Yeah, some of them.
Most of them.
Most of them.
Yeah. There are specific rules, actually, regarding attorneys acting as witnesses. And what they basically, the specific rule, I think it's 3.8, I think, is an attorney can't act as an advocate and a witness in the same manner, which if you've ever heard me scream the words, you never make yourself a fact witness, that's why. But there are other ethical rules out there. Rule 3.3, candor towards the tribunal. That means we cannot lie to the court, nor can we permit other people to do so or assist them in doing so. We have to disclose those things to the court when they happen. And there's roundabout ways we do them. However, I've acted as a witness in a case where I was not pressing the charges. I was called as a witness, and my former client had waived confidentiality. And do you know how I was sworn in? When I sat on the stand, the judge looked at me and said, "Please recall that your oath as an attorney is still in effect, and you still owe a duty of candor to this tribunal."
Nothing like reminding you of your oath.
Oh yeah.
It, yeah, just really drives the point home there, I guess.
So even appearing as a witness or a defendant in a case, an attorney can still be bound by the rules of professional conduct. As a matter of fact, you can be bound by the rules of professional conduct before you're even an attorney. I will bring up the case that Scuff couldn't pronounce earlier. This is a Pennsylvania disciplinary opinion. It's a 2004 opinion. It's the Office of Disciplinary Counsel, which is Pennsylvania's disciplinary board, against Akeem Frederick Sismus. Mr. Frederick had been a medical practitioner before he went to law school. He became an attorney when he before becoming an attorney was not a medical practitioner because he had disciplinary actions brought against him by the board of medicine, and he had lost his license that had been revoked while he was in California. He moved to Pennsylvania. He attended Temple Law. He took the New Jersey and the Pennsylvania bar exams after applying to do so, because you have to apply to sit for the bar exam. And he passed the bars. He was a practicing attorney for years. 4 years on this. At least he passed the bar in 1995. He was a practicing attorney 5 or 6 years. And then they found out that he had been removed from medical practice, which he had not disclosed on his bar applications. And what do you think happened to him?
Well, I'm going to go ahead and guess that he lost his license to practice. I mean, you can do a lot of stuff before you're a lawyer, but if you fail to disclose it to that's when the bar gets pretty angry.
Yeah, lying to a court and lying in the office in any sort of official capacity is usually a one-way ticket to either disbarment or a long enough suspension that you might as well have been disbarred.
And I will point out that Sismus had no record of prior discipline in 2001 when all this was looked at. There was no record of prior discipline. He had not been disciplined in general before that. No public reprimands, no private reprimands. By all accounts, he was actually an ethical attorney while he was in the practice of law. However, his failure to disclose on the bar applications, on the thing you have to fill out to apply to be an attorney, to take that exam, was enough to warrant disbarment and removal of his license. There are cases out there where it's been discovered after 10 years in practice that somebody lied on their law school application and have lost their ticket to practice. As a result, we are a profession that, although people joke and say liar and lawyer are the same word, takes our duties of candor to the profession very seriously on that. As a matter of fact, what does it do? A good question from the chat. What does that do to the cases they've tried? 99% of the time, it won't affect anything. Times where it would? Well, Scuff, you can speak to that. What happens when a prosecutor has gained convictions and then you find out they have a history of Brady violations?
I mean, you would review other cases to see if there were potentially Brady violations in those cases, and
it's fucking open season for post-conviction relief motions, isn't it?
It is open season. Probably not as successfully as most people would hope. But yeah.
Yeah.
I thought you were taking that in an entirely different direction.
No. And I like they'll lose their fucking license. And if they don't lose their license, they won't be a prosecutor anymore if it's proven. But I would say, correct me if I'm wrong, what is probably the most common reason attorneys get disbarred?
I mean, taking client money seems to be up there. I would say taking clients' money and then crimes of dishonesty, like either of those two. are going to be very high. You can get 5 DUIs, but if you get 1 forgery, you may lose your license.
Yeah. You can do a lot of shit, but being dishonest or fucking with the trust account, those
Which
are
falls under the heading of dishonesty.
yeah, those are straight out of the, well, not always. Sometimes somebody takes money out of the client trust thinking they're going to pay it back at the end of the month, and they never do. Or they get so far behind. I mean, I'm familiar with attorneys that has happened to. But your quickest ticket out of the legal profession is abusing the client's trust or just being dishonest, showing yourself not trustworthy of being an attorney. And by the way, you would think it's a very high bar to be so dishonest that even lawyers don't want anything to do with you. It's not. We like lawyers by and large. Most attorneys on here, they don't want shit to do with you if they find out you're falsifying things or you're taking money. You could shoot a man, and more lawyers would be like, well, you know, he's having a hard time. But you steal fucking client money or you lie to the court, and most lawyers would be like, that fucking scumbag.
Yep.
I mean, we
Yeah,
say
I
that.
mean,
I think we say this in
go ahead.
every. I think we say this in every panel we do. But in our profession, your reputation is your number one currency. Once you lose people's trust, it's so hard to even practice because no one believes a thing you say.
So, buddy, I did say we're gonna go for probably about. Somebody said, "What about bailing on clients?" Tyro Thunderdome was asked, "What about bailing
You
on clients?"
definitely don't do that.
That depends on what you mean by bailing on clients. Like just
Well, obviously.
just a fucking
Okay, the
peering.
lawyer answer,
Yeah.
it depends.
Just a fucking
Yeah, I mean,
peering.
if you
Yeah.
right, that's obviously you can't do that. I mean, if you go through the whole process of withdrawing and getting the court's approval to be terminated as a, or if the client terminates you, that's a different story altogether. That's a different story.
Like
But
I've had that case. I've been down at court on a hearing with a client on one matter, found out that client had another matter that their attorney on that matter was aware of, and just said, "Decide I haven't been paid, so I'm not coming," and hadn't withdrawn. And I stepped out of the courtroom, gave them a call, and said, "Hey, you're about to get a disciplinary complaint filed against you. You may want to get your ass here." Um, and you know that I've saved people's asses before on that one. And that's another thing. You have to understand. Attorneys protect each other. Like I'm not going to bullshit and say we don't. We do. Uh, but there's certain lines that even attorneys who are protecting each other somewhat will not fucking cross. Like in that situation, had he said no, fuck you, and hung up on me, and I went back in and told the judge, yeah, they're not here, Your Honor. The judge was going to ask me, have you contacted them? Yes, I contacted. I'm not in on this matter, but yeah, I contacted them. What they say? They told me to go fuck myself, Your Honor. But their response of, oh shit, could you tell the court I forgot, or yeah, that's where you go, Your Honor, can I have a sidebar, and you walk over and you say, I contacted him and there was a scheduling error, Your Honor, and if you would reschedule, they'll certainly appear next time. And it doesn't harm the client, and it can keep somebody out of some serious fucking hot water on it. And then you tell people in the future, don't go to that guy. Don't go to him. The other thing is a lot of attorneys, and correct me if I'm wrong in this experience, Scuff, you've probably seen it in the criminal bar before. We are very familiar with when another attorney is having issues. And at that point, we have a tendency to kind of close ranks and try to get them help or offer them help or take things off their hands for them. To do that, not only for the protection of the attorney, because we are colleagues, whether we hate each other or not, we're colleagues, but for the protection of the clients as well at that point. So,
I have seen it. I mean, it's so weird because from the prosecutorial side, we don't. You often get in this. I don't know. Every town's different. The town I came from, it it definitely crossed the line into being way overprotective, even to the point of fucking over clients pretty hard. The judges routinely violated several rules of ethical conduct, and I mean, sometimes I'd be there and I'd just be like, you shaking your head, like, holy, why did you fucking think that was okay? I mean, and it's my experience is very different than yours, Boozy. I would tend to say, I tend to be more cynical. I think attorneys overprotect one another. I think a lot of times the disciplinary committees overprotect lawyers, even from very harmful situations. I think a lot. I think to me, it strikes me that most people who actually get disciplined, and this is going to be a very cynical take, tend to be outsiders. They're not part of the club. I think once people are in the club, they get protected real hard. And I think when people are kind of outsiders, they get thrown to the wolves. And it's a lot more common because if you're an outsider and you don't fit in the legal community, you make a lot of mistakes because you don't have someone backstopping.
Yeah, the good old boy network is definitely real. I mean, I've had some experiences down here that, um, yeah, definitely evidence the fact that there is, uh, I'm not even wording this well, but you get what I'm going for.
Yeah.
Um, yeah, I think that in some cases that's the case.
I mean,
There's actually a question in the chat I think is pretty relevant here from Head Fox. And are there resources available to lawyers for mental health and support and care that are different than what's available to us normies? I mean, the short answer is no. But
Well,
yeah, yes, we have
yeah.
something.
The short answer is no, because they're not different in the traditional sense. But the answer really is yes.
We have things called legal assistance programs, and usually it's the initial letter of your state, and then LAP. So mine is KLAP, Kansas Legal Assistance Program. And I mean, I had issues. A very terrible thing happened at my last job, and I needed mental health services, and I called KLAP, and they paid for a number of psychiatric visits because that was available. But it wasn't like a lawyer specific psychologist, it was just a counselor, and KLAP paid for.
And it's different from each state. In Pennsylvania, it's called Lawyers Concerned for Lawyers. And the services really are, especially when it comes to like mental health groups and substance abuse groups. They really are lawyer specific. Something that stopped a lot of the members of the old guard of attorneys from seeking health. I mean, we are in a profession with a very high rate of mental illness and substance abuse. And something that would stop a lot of attorneys from seeking help was a fear of being outed, especially in the pre-advertising days when it was all word of mouth. If you went to AA as a lawyer at the church in your town, everybody knew. That's the lawyer who's in AA. That's the lawyer who's in Narcotics Anonymous. It was stopping people from going to go get help. Like Lawyers Concerned for Lawyers here in Pennsylvania has specific groups. They have AA groups, they have Narcotics Anonymous groups, they have mental health support groups that are nothing but judges, attorneys, and former attorneys. So that there is a safe environment for attorneys to seek help without the fear of professional or social backlash as a result of it. Especially in private practice, because when you're in private practice, your reputation is what you sell.
And you're constantly selling. That's one of the reasons I could never do that. I hate having to act as a salesman because I don't know. I mean, my opinion is that most people could probably do legal work if they were educated in it, and it's a whole thing. But anyway, where's I going with that? Oh, right. Um, but your reputation really is what you're selling. I mean, they have to trust that you, as a lawyer, are going to be the best person for them. So, you can't lose that trust.
And to kind of like I say all the time, I grew up in my father's law office, and it's probably a little bit why I have a different perspective on the bar and the insular network on that, because my father very much was part of the old guard in the town I grew up in. He was well known by everybody. He was a respected attorney. My father also has a mental illness that for years he did not seek treatment for because he was scared of how it would impact him professionally. And thank God he finally did seek treatment. Uh, but lawyers that I grew up around when I was growing up in Dad's office are no longer with us. They died of drug overdoses. They swallowed shotguns, things like that. There very much is, especially among older attorneys and older legal practitioners, a stigma surrounding those things. And the people who end up hurting the most outside of the attorney themselves when there's an undiagnosed mental illness and when there is an untreated substance abuse issue is the client at the end of the day. Those are the people who are left holding the bag of having to clean up the mess and move on from that is the client whose issue didn't get any attention, the client whose money got stolen, the client who's suddenly left without an attorney because their lawyer got disbarred for their 18th DUI. Those are the ones that end up getting affected because those are ethical violations at the end of the day. And that's why it's so important that we have those assistance groups because at the end of the day, we're not just protecting lawyers, we're protecting their clients as well and the public in general from having an attorney who is not capable through no fault of their own most of the time, but at that time is not capable of adequately representing people. Wow, we got heavy.
Yep.
Yeah,
I mean, ethics
yeah.
gets heavy.
Well, and that's kind of why you have the support system in place for this kind of thing. I mean, it can get to be too much for one person to do on their own if they're the only one out there trying to uphold their personal ethics in a field that sometimes, due to the pressures of capitalism, don't encourage it.
Well, I think, buddy, I think you led us into a great final topic for tonight. Attorney ethics and personal ethics. Are they the same thing?
Absolutely not.
No.
No,
Actually,
attorney ethics are a bare minimum level of ethical principles and behavior. Anything you add on top of that, personally, is it's gravy.
Well, let me ask, should your personal ethics inform how you practice as an attorney?
To a degree. I mean, if there, I couldn't honestly say that they shouldn't impact it at all. Um, but there are certain cases where your own personal ethics and your professional ethics are going to be at odds.
I think it's a bigger issue for a defense attorney than it is for, or even for like a private civil attorney than it is for me. Um, I, if my ethics were in conflict with the professional rules that bound me, I would be a terrible person. My personal ethics typically make me go further than the law requires me to, and actually, I mean, kind of leads into an example where I reported someone to the bar. There was an older defense attorney. He clearly was going through stages of dementia, and he had very bad hearing, so he'd have to have his clients talk really loud. And his client was talking, and his client had just pleaded guilty to robbery. And Kansas has a sentencing grid. And it was my understanding, based on what I had seen from his priors, that he had one prior person felony. And that meant that, and we were going to run his cases consecutive, and it meant that he was going to run 0 days on my case. He would run all of his time on his other case, and he would do no additional time on ours. As he's talking to his attorney, he says, no, I didn't plead to 1 count. In the other case, I pled to 3. And the guy just goes, okay, and then just keeps having him sign this plea deal. Well, what that meant is that he was going to do 20 years on my case instead of 6 that he was going to do. He would have done 20 total. And his attorney almost made him do 20 years. And I heard this happening. And there is no ethical rule that I stand in for this guy. He's got he's got counsel. But my personal ethics say, I didn't want this guy to go to prison for 20 years. I'm not going to send him to 20 years because his attorney has dementia. And so I said, Al, if he signs that, he will go to prison for 20 years. And this attorney did not understand. I had to walk his attorney in front of him through, like, if you have him go through with the plea as it is written on that page, he will do 20 years in prison. And finally, the client was like, I'm not taking the plea. And I'm like, cool, we're going to renegotiate the plea so you get what we had bargained for. And I reported him to the disciplinary commission because at that point, like, you can't always count on the person on the other side being me who has this view of right and wrong. And this is why I'm so cynical. The attorney disciplinary commission did nothing, and I got a personal sit down from the local attorney disciplinary coordinator who said, drop it.
Well, and I to bring this up, and this actually may be, well, it almost certainly, because I can tell you, I know that lawyer, not that specific, but I know the type of lawyer you're talking about. As a matter of fact, one of my father's law partners for a number of years was a gentleman who was in a very similar situation, to the point where Dad had said, no, you're not taking any more trial cases. You do the fucking wills. And do we need, for small and solo practitioners, small firm practitioners, solo practitioners, do we need something like maybe what SAG has? When you look at the Screen Actors Guild, for a number of years, there was no way that a star, after their shine had fallen off, could plan for a retirement. And you have a lot of attorneys, and it's like the noble thing of the small and solo practitioner. They'll die at their desk, 90 years old, trying a case. That's how they're going to go. But the sad reality of it is a lot of small and solo practitioners, they don't make large amounts of money. Most of them cannot save adequately for retirement, and they end up practicing long after they should have stopped because there's a lack of support for elderly counsel out there.
It's
Was there a
capitalism.
question?
I mean, like, it's a capitalism problem.
Yeah.
No one should have to work no one should have to work after they're 75. No one should have to work into their 80. You should not have to work that long just to keep a roof over your head. But
Right.
because private attorneys, a lot of them in small practices, don't have pensions because they've only ever worked for themselves. They just can't quit. I mean, it's not that they want, a lot of them I don't think want to work every day until they die. I think a lot of them have to work because you'll lose everything the minute you stop.
And the fact of the matter is, and you hear people, oh, we'll get a small IRA or things like that. Let me describe what it was like growing up in my father's practice. My father started his own practice. He did a lot of personal injury work. He took cases for much less than he should have because he believed everybody needed representation. And when you're doing that, what you make, what you're making, it's not a salary. It's not a paycheck you take home at twice a month. That money is what keeps your home going and keeps your office going. So you split it, and you would have good years and you would have horrible years, and you scrolled away for the horrible years to keep the office doors open so that you could keep practicing law on that. And those are real threats for the older attorney. I personally will probably never retire. I will likely never retire. I will practice until I am completely unable to practice. Because when I look at my retirement account, and I'm lucky enough that I have a retirement account, I look at my retirement account and I say, there's no way I'm going to be able to live on that in Social Security. There's no way on that. And that's just the sad reality of it. And at the end of the day, it ends up hurting the clients. But then you have the guys in the bar, the people in the bar who look at these older attorneys, and looking at them, they shouldn't be practicing anymore. But if they lose their ticket, they got nowhere else to go. They don't have money saved up. They don't have an ability to live without it. And my father recently hit that point last year. He told his clients, after I finish up the trial work I have, I'm not taking any more trial work. My dad's in his late 60s. He just said, I don't have the ability to keep up with it like I used to. My office has gotten smaller. I'm not going to take trial work anymore. I can live very well doing estate work and some disability cases and bankruptcies at this point in my life. And he's in a very good position because he did have some good cases that allowed him to take care of a lot of that, but he doesn't have a retirement either. And that's just how it is. Now, on to the question of personal ethics versus professional ethics, though. I agree that your personal ethics should inform to some extent how you practice law, but it can't completely inform it, especially because we actually have a model rule. And Scuff, you telegraphed that when you said, I think it comes into practice more for the private attorneys, which is Rule 1.2, the scope of representation, the allocation of authority between your client and your lawyer. And if you scroll all the way down to B there, it's actually the second one of the second rule of professional conduct. A lawyer's representation of a client, including representation by appointment, does not constitute an endorsement of the client's political, economic, social, or moral views or activities. Why do we have that rule?
So that we can stop putting on our Twitter accounts, RTs are not endorsements.
Essentially, our job, and this is coming from a private attorney. Okay, my job
our
is
job is to represent people. Like
exactly.
Everybody is entitled to legal representation, even reprehensible people.
I have my own personal moral system. I have my own personal views on many things. But one thing I'll tell my clients on a regular basis, I'm not your dad. I'm not your preacher. I'm not your high school teacher. I'm not your mama. I'm not here to judge you. Frankly, I don't care what you've done. The amount that I care depends wholly on how much does it affect your case. And the idea behind that is very simple. Buddy just said it. It doesn't matter how reprehensible you are. You deserve a lawyer because otherwise this system doesn't work. So we're 7 minutes out from the end. And I'd like to invite you all to give final thoughts on legal ethics in our talk tonight.
I'm waiting for you to go, buddy, because I feel like I've dominated the.
Oh, no, my
Oh, I'll have Buddy back on several times. Buddy,
Oh, well,
Buddy doesn't realize it, but Buddy's my new podcast bitch. I love
buy
that.
a girl a drink first.
I love the I've bought you drinks before.
That's true. Yeah. All right. Well, maybe a T-shirt that says "podcast bitch."
I will do that tonight. I will make one. I'll put it on the merch store and I will send it to you. Boozy's podcast bitch.
Sounds good to me. Yeah. Well, frankly, rules of professional ethics kind of come up in your fields more than mine. And as an in-house attorney, if I'm in court, I have done something wrong. We have real lawyers for that kind of thing. So basically, what comes into play in my field would be conflicts of interest. That's going to be the main thing. In-house counsel is still bound by the same rules of professional ethics as everybody else, except our client is the corporation that we work for. So my client is the medical practice that I work for, not any individual component of it. So no individual person is my client. That leads to, some interesting cases where I may create conflicts of interest if somebody leaves the practice and then comes back later as a competitor. And if I've offered them legal advice, then I've created a conflict of interest for myself. So this is actually came up a couple of times when I was working at a government staffing agency. It had a couple of spin-off companies that they were trying to get going, but they all relied on the same pool of in-house counsels as their legal advice, which is a terrible, terrible idea and should never be done. Everybody should have their own individual legal counsel, and that's a point that I made consistently, to little effect, which is one of the reasons I'm not working there anymore. And that's that's an example of my personal ethics and professional ethics lining up pretty well and informing what my next career move was, i.e., leaving that place. But so I mean, an employee at this company isn't necessarily going to be my client, and I have an obligation, for example, to let them know that. So I'm required to give people what's called upjohn warnings. So I'm talking to them in my professional capacity as their attorney. Um, Basically, what that means is I have to let them know that the corporation is my client and that the corporation has um, they've got the attorney-client privilege. They're the ones who can waive that or not. So anything that they say may be divulged later and may not be. Um, yeah, so that's something that I've had to deal with a couple of times. Fortunately, not often, but yeah, conflicts of interest are something that I really have to keep an eye on where I am right now. Luckily, most of most of the employees are smart enough to take my advice when I say you need to get your own legal counsel for this.
Well, I think, buddy, that if you are game, in 2 weeks, I'd like to have you back for another interview one, just specifically talk about in-house counsel.
Um,
Oh
sure. I mean,
yeah.
I don't
Rub
believe I have
those
anything
bits
going
all over my
next two
face.
weeks, so sure.
All right. Do you have
We've got
final
a couple
thoughts?
other members of the FBA who might be interested in
Yeah,
that also.
I know. I actually have one in mind to join you.
Excellent.
So, Scuff, final thoughts?
I mean, legal ethics is, and legal ethics is one of those fields where it seems like it should be obvious. Don't fuck your clients, literally or figuratively. Don't steal from your clients. Don't lie. But it's in my case, in prosecutors' cases, the biggest thing that gets us in trouble is the competitive nature of the beast. Unlike other fields where there's money involved that we can take, like I can't steal from my employer except for the pens that I forget to take out of my pockets. I can't steal lots and lots of money from my employer, but I can get super competitive with a defense attorney and decide that I'm gonna maybe not mention something that I know, or in a case that happened, I can't remember which jurisdiction, a prosecutor pretended to be the jilted lover of a defendant on Facebook to try to get information on that case. And when you're in the middle of it and when you tunnel vision in on what you're doing, you'll make a million excuses for why you broke the rules, even though they're not that hard to figure out, they're not that hard to follow. You'll make excuses in that moment that you're about to do it. So, the reason we review these things and talk about these things is to remind ourselves, because if you remind yourself enough, it might trigger you to remember in those horrible moments where maybe I could take a couple $1,000s out of the client trust fund account to just cover my bills this month, or maybe I could get away with not telling the defense attorney about this witness who just came in and told me I got the wrong guy. Maybe who's going to find out? You have to remind yourself that these are the rules that govern us.
Well, I want to thank both of you for coming on tonight very much. I know it was kind of last second for both of you. I contacted you this morning and said, hey, come on, because I had poor planning on this one. So thank you, Scuff. Thank you, buddy.
Thank you. It's always a pleasure.
Thank you.
We will be back next week with another legal funhouse. If you're in the Discord or otherwise, please feel free to give me a topic for it. I'll be happy to do it. Hopefully, in 2 weeks, I'll have Buddy back with somebody else to talk about the rigors of in-house life. You latte sipping bastards. Um,
Actually, I switched to mocha this morning.
yeah. And otherwise, thank you all for joining us tonight. It's always a pleasure to have everyone tune in to hear lawyers talk about shit you couldn't care less about. So until next week, I am the Boozy Badger, Boozy Barrister. You are not, and I will see you next time. Now we're going to go to the credits, and you're going to listen while the credits are rolling to the three of us talking over them. Good night. Well, I think that went well.
Yeah, it was a ton of fun.
It really was.
Yeah.
You did very well, Scuff. I'm proud of you.
Oh, thank
I'm
you.
sorry for talking over you the entire time.
No, I felt like I talked over you the whole time. I'm like, oh my god, Buddy's not getting a word in edgewise.
Like-
Oh no, I would have jumped in. You're fine.
Okay.
Like Buddy's always very quiet when there's a stream with a bunch of lawyers, and then Buddy comes out with just something that's like so deep every attorney pauses.
Yeah, I mean, I don't know. On some level, I kind of feel like you guys are the real lawyers, and I just kind of, I do paperwork.
No, I you know what's weird is since I stopped litigating, I definitely have those moments of like, am I a real lawyer